You can give him an extra round of applause. He finished a minute early. I've got a couple housekeeping notes here. And by the way, I see conservative columnist Jack Kenny in the back of the room. Jack, if you want to say hello to everyone here. All right. How many of you have one of these? This is what you get from the parking lot across the street. How many of you have one of these? If you don't want to pay for your parking, you have to get one of these. If you don't have one of these, find Diane or somebody who was working at the front desk. They have them. So, oh, by the way, ladies and gentlemen, I mentioned her earlier. There's Karen Testerman. Give her a round. Okay? So now please, drivers only. That's in my notes. I have to say drivers only. So if you have the white ticket from the parking lot across the street and you do not have a blue one, stand up so we can throw things at you. Okay, they will get you the blue tickets. All right. Now, while people are getting their tickets taken care of, I will get started on introducing the first of our primary speakers. Our next speaker, who I had the privilege of interviewing on my radio show last week, has been practicing law for more than 30 years with an emphasis on constitutional issues. He's one of our country's most eminent constitutional attorneys, having brought 4 cases before the Supreme Court, winning 3 of them. He is also considered the foremost authority regarding constitutional money systems, well known and respected for his 2-volume work entitled Pieces of 8, The Monetary Powers and Disabilities of the United States Constitution, the most comprehensive study in existence of American monetary law and history from a constitutional perspective. Add to that his work as co-author of the political novel Crashmaker, A Federal Affair, which is turning out to be a not-so-fictional story of an engineered crash of the Federal Reserve System and the political upheaval it causes. Dr. Edwin Veira, Jr. holds 4 degrees from Harvard, to include a Master of Arts and a doctorate from the Harvard Graduate School of Arts and Sciences and a JD from Harvard Law. Please welcome Dr. Edwin Veira to speak tonight on the administrative state blueprint for tyranny. Doctor, you have a half an hour, maybe 35 minutes.
Ladies and gentlemen, it's always my pleasure to address this gathering. I've been here on a number of occasions. Tonight I have a subject which was commissioned by Diane, and to me it's dry as eating gypsum board. But it may be interesting to you because it does have some serious consequences. The relationship between administrative agencies and tyranny. To begin with anything of this nature, you have to start with some definitions. Administrative agencies are governmental establishments that are composed of unelected professional career bureaucrats who serve for indefinite periods of time. The mandates of these agencies cover specific fields of interest and supposed expertise of those bureaucrats. Now, although in traditional understanding, an agent always has and is accountable to a principal, a modern administrative agency is considered in some sense independent of the legislative, executive, and judicial branches of the general government. This is particularly peculiar in that the Constitution provides for not a single administrative agency. Instead, every administrative agency is the creature of Congress, yet every administrative agency is supposedly somehow independent of Congress. Now, proponents of administrative agencies in the administrative state will contend that these agencies, largely independent of the legislative, executive, and judicial branches, must exist so that decisions crucial to the regulation of economic and social affairs in this country can be made by experts on a supposedly non-political basis. How do they operate? Well, administrative agencies generally dispose of some combination of quasi-legislative, quasi-executive, and quasi-judicial authority. They promulgate regulations, guidelines, and directives for the interpretation of the particular statutes which have created them. That's their quasi-legislative function. They investigate and prosecute violations of the enabling statutes and the regulations they have enacted. That's the quasi-executive function. And in some instances, they even adjudicate these violations, and that's the quasi-judicial function. Today, many, if not most, of the important substantive decisions as to what basic policies are to be adopted in Washington are made on a day-to-day basis by administrative agencies and not really by the legislative, executive, and judicial branches of the government at all. Power, in fact, has become so centralized in dozens of these interlocking agencies as to make the agencies a veritable administrative state unto itself. I could give you a lot of examples. A prime example is the Federal Trade Commission. Now, that's a very apt example because most people associate the rise of the administrative state and administrative agencies with the administrations of Franklin D. Roosevelt in the 1930s and 1940s. The FTC, however, was created nearly a generation earlier with the administration of Woodrow Wilson in 1914. And of course, Roosevelt was an Assistant Secretary of the Navy in the Wilson administration, and he learned the lessons of centralized government in that particular school. Now, the Federal Trade Commission is one that the Supreme Court has talked about at some length in various occasions. 1935, for example, a case called Humphrey's Executor versus the United States. You're all familiar with that. I don't have to go into the details of that case. But the Supreme Court did observe that the history of the Federal Trade Commission, quote, demonstrates the congressional intent to create a body of experts who shall gain experience by length of service, a body which shall be independent of executive authority and free to exercise its judgment without the leave or hindrance of any other official or any department of the government. Now, that statement neatly encapsulates the essence of these agencies: expertise, independence, duration of service. Now, in that same case, the Supreme Court went on to describe the FTC as an administrative body created by Congress to carry into effect legislative policies embodied in the statute in accordance with the legislative. I can go on and on with this, this gibberish. The Commission acts in part quasi-legislatively and in part quasi-judicially. To the extent that it exercises any executive functions as distinguished from executive power in the constitutional sense, it does so in discharge of its quasi-legislative and quasi-judicial powers as an agency of the legislative or judicial branches of the government. Now, the reason I've quoted that is because notice the mysterious aspect of what they're saying. To the extent that the FTC exercises any executive functions as distinguished from executive power in the constitutional sense, it does so in discharge of quasi-legislative or quasi-judicial power. But what are executive functions distinguished from executive power in the constitutional sense? Where does the Constitution provide for or permit the exercise of executive functions separate from executive power? Indeed, how logically can functions be separated from powers that relate to them? And how constitutionally can an agency of the legislative or judicial departments of the government execute executive functions any more than can the legislative or judicial departments of the government itself? Well, the court didn't say, for the obvious reason there is no answer to those questions, right? Now, most people here today, I suppose, can list many other alphabet agencies with structures, functions, and breadths of mandates similar to the FTC: Securities and Exchange Commission, Food and Drug Administration, Environmental Protection Agency, Internal Revenue Service, Federal Reserve System. We could go on and on. The question is, to what extent are these independent administrative agencies consistent with the Constitution? Well, analysis of the propriety of these agencies must begin with a precept that was long recognized in Anglo-American law far earlier than anyone ever thought of the Constitution of the United States. And that principle is that a delegated power cannot be delegated. John Locke, probably most of you are familiar with his second treatise of government, in section 141, he says, rather absolutely, the legislative cannot transfer the power of making laws to any other hands. For it being but a delegated power from the people, they who have it cannot pass it over to others. The power of the legislative being derived from the people by a positive voluntary grant and institution can be no other than what that positive grant conveyed, which being only to make laws and not to make legislators, the legislative can have no power to transfer that authority of making laws or place it in any other hands. Pretty straightforward. So in light of this precept, which underlies the whole body of Anglo-American legislative law, any delegation of Congress's legislative powers to some independent administrative agency must be highly suspect. Well, more than that, the Constitution plainly outlaws every delegation by Congress of congressional authority, because it mandates in Article 1, Section 1, that all legislative powers herein granted shall be vested in a Congress of the United States. And even the Supreme Court, 1913, case of Ettore versus City of Tacoma, recognized that a right that is vested cannot be defeated by subsequent legislation. The only legislative powers which the Constitution grants are those which it grants to Congress. And Congress can exercise only those legislative powers which have been granted by the Constitution. Kind of a circle there, right? The Constitution delegates to Congress no general power of delegation of legislative authority. In fact, I don't think the word delegation appears in the Constitution at all. Therefore, Congress cannot, by subsequent legislation, that is, by the exercise of any of its powers, which are all legislative powers, by constitutional definition, it cannot transfer to anyone else a power constitutionally vested in itself, QED, end of discussion. And even the Supreme Court, in one of its rare lucid moments, in Panama Refining Company versus Ryan in 1935, and I do recommend that anyone who wants to read a really good opinion of the Supreme Court, that's one of them, all right? It held on the basis of Article 1, Section 1, that Congress manifestly is not permitted to abdicate or to transfer to others the essential legislative functions with which it is vested. That would seem to close the door. The Constitution says that, the Supreme Court says, but listen, unfortunately, even in this decision, the court qualified its statement with the weasel word, essential. Right? It's not, Congress is not authorized to transfer its essential legislative functions. A qualification which, of course, does not appear anywhere in the Constitution. As far as the Constitution is concerned, all of Congress's legislative functions are essential, or the Constitution would not include them. Right? And I might carry on with this to point out that this same concept of vested powers occurs in Article 2 with respect to the President, and Article 3 with respect to the judiciary, and it has never been held by anyone that the President could delegate his presidential authority to some kind of administrative agency, or the judiciary could do this either. Well, where did this concept arise? It actually didn't arise with Roosevelt and didn't arise with Wilson. Notwithstanding what the Constitution says, in 1825, the Supreme Court, and once again we come to the usual suspect in this problem. We come back to the Supreme Court in the case called Wayman versus Southard, proffered a very loose theory, and that is, and I quote, Congress may certainly delegate to others powers which the legislature could rightfully exercise itself. The line has not been exactly drawn which separates those important subjects, which must be entirely regulated by the legislature itself, from those of less interest, in which a general provision may be made and power given to those who are to act under such general provisions to fill up the details. All right? This little bit of fuzzy language is the basis of the whole system. Think about that for a second. Now, according to this decision, filling up the details can justify a delegation because it does not constitute the performance in the constitutional sense of the legislative function. One is entitled to ask, however, what sort of function in the constitutional sense does such a delegation perform if it is not a legislative function? After all, it is a delegation of legislative authority from a legislature. And by what criteria can those important subjects, which must be entirely regulated by Congress, be separated from those subjects of less interest?
Crop TV.